Hi, and welcome to our webcast for January 26, 2018.
Yeah.
It says 17, but we doesn't have to lose a year. Okay. My name is Christian Debré, and this is Amy Asbrook, the director of Toujours Vivant Not Dead Yet. Also joining us,
Well,
maybe,
if her computer will work.
yeah, Taylor Hyatt, our policy analyst and
Analyst.
outreach coordinator.
Yeah.
Never know. Okay. Toujours Vivant Not Dead Yet is a non-religion organization by and for people with disabilities and our allies. Our goal is to inform, unify, and give voice to the disability rights opposition to assisted suicide, euthanasia, and other ending of life practices that discriminate against people with disabilities. Today's topics: review of Canadian disability rights legislation, the territoire. This is the last thing that we of our series.
Yeah.
And the second one is announcement. We need YouTube subscriber. We need 100 subscriber minimum.
Wait. Okay. Before we start, I want to apologize. Last week we had a technical glitch and it stopped during the webcast.
We apologize for that, but that was not our fault.
Right. Okay. Review of Canadian territories. So welcome to the final part of our series on disability rights laws in Canada's provinces and territories. We've covered the southern portion of the country. All that's left is the three northern territories: Nunavut, the Northwest Territory, and the Yukon.
Very vast, but
yeah, only 120,000 people there. So given that, we've gathered all three territories into one webcast.
Very few people.
Right. We'll focus on how disability rights are handled under the territory's Human Rights Acts and some case studies. As with all human rights acts, the Northern Territories recognize disability, several grounds for promoting equality and preventing discrimination, along with factors like race, gender identity, religion, or age. So disability kind of gets lumped in there, but they do, in the laws, they do provide some, there are some sections that deal with the extra steps that need to be taken to make disability equality a reality. There are similarities and differences among the definition of disability in the three laws, because you have to start out by defining disability. Under the Northwest Territories Human Rights Act, disability is defined as any degree of physical disability, infirmity, malformation, or disfigurement that is caused by bodily injury, birth defect, or illness, and a condition of mental impairment or a developmental disability, a learning disability, a dysfunction in one or more of the processes involved in understanding or using symbols or language, which is an interesting one, or a mental disorder. And so there's the thing about using languages and learning disability, and then they just say a mental disorder. And I think what they mean is a psychiatric disability, mental illness, but they don't define what a mental disorder is. So we have to guess that that's probably what they mean. The Act also protects people who have had a disability, those who are believed to have a disability, and someone with a predisposition to developing a disability. And that's an important inclusion as well, because we know that if somebody used to have a disability, and they're discriminated against based on that fact, or somebody says, hey, well, I remember he used to be really sick, so we don't want to hire him. No, that's not going to fly. And also, if somebody is not hired because the hiring committee thinks they might have a disability or they might develop one, well, didn't his father have Huntington's disease? We can't hire this guy. No, you can't do that.
You can't do that.
So, okay. Nunavut's Human Rights Act defines disability as any previous existing or perceived mental or physical disability. So there's previous, existing, or perceived. There's those three things. Physical or mental disability, including disfigurement and previous or existing dependency on alcohol and drugs. So they add that one. And what they've done here is they've given a very general definition, so it includes a lot of things. They don't mention specifics, they just made it very general. In the Yukon Human Rights Act, physical and mental disabilities are defined separately. Mental disability means any mental or psychological disorder, such as organic brain syndrome, emotional or mental illness, or learning disability. So they start doing a little list there. And physical disability means any degree of physical disability, infirmity, malformation, or disfigurement that is caused by bodily injury, birth defect, or illness. And
seems to be fairly complete.
Yeah, it's fairly complete, but that one doesn't get into the perceived as disability type thing. Under the Northwest Territories Act, discrimination does not require an intention to discriminate. Nunavut has a similar provision, and the Yukon Act implies that intent is not required. Any conduct that results in discrimination is discrimination. So actually, it's interesting because in the French version, it's stated explicitly that intent is not required. In here, in the English version, it just says any conduct that results in discrimination is discrimination. So it doesn't explicitly say that intent is not required. Kind of interesting when you read the two versions. In all three laws, discrimination is prohibited in hiring and all aspects of the employment relationship, membership in unions or professional organizations, provision of goods and services, access to accommodation and facilities, and tenancy. So they include housing, and that's good. I think, I can't remember if all of them talked about contractual relationships, but that might also apply to, getting mortgages and being able to buy a house or that sort of thing. So it's a fairly broad spectrum of coverage.
Yeah.
It doesn't mention that, it doesn't mention specifically that the provincial and local governments are covered, but they are.
Yeah, I agree, but it looked like they tried to be the widest possible definition.
Yeah, and one thing about the definition of disability in these three laws is that it doesn't get to the issue of functional or the interaction between the disability and the environment. So that's something that's World Health Organization's and the United Nations definition of disability does that these don't. And it's kind of interesting that they chose not to do that. Discrimination means different things depending on the setting. Some forbidden practices are preventing disabled people from taking advantage of goods and services, failing to accommodate a person's disability without good reason, discharging or expelling someone because of their disability. So if somebody has a guide dog and they're kicked out of a restaurant, that would be an example of that. Intimidating or harassing someone because they complained about discrimination. So if somebody came into a restaurant and they were kicked out, and then they tried to go in again at another time with a paper that says, this is my guide dog and this is who trained it and blah, blah, blah. And the restaurant owner got pissed off because the person's trying to assert their rights. That's another form of discrimination. All three statutes allow an exception to the non-discrimination mandate for reasonable justifications. This usually refers to when providing an accommodation would impose an undue hardship. And that's a term that's used in lots of discrimination laws. It's been used in the Rehabilitation Act in the United States since the early 70s. And the term has been defined and refined by court cases since that time. And so they've laid down a pretty good basis for what that means. Let's see, reasonable justification could also include if the person had a criminal record or would be unable to do a job even with accommodations. So those are a couple of circumstances where each Human Rights Act has an undue hardship provision, which removes the duty to accommodate should the burden and cost become unreasonable. Both the Yukon and Nunavut Human Rights Acts list factors to consider in deciding if something is an undue hardship. And again, this comes from case law in Canada from the Supreme Court. So they took from those decisions and they put it in the law. So they need to consider health and safety, disruption to the public, the effects on contractual obligations, the cost, and business efficiency. But the Supreme Court is not very sympathetic to people who say it's an undue hardship. They're pretty good about saying, no, you can't get away with that. And it does depend on the size of the business and what's being asked, but an accommodation usually doesn't result in an undue hardship unless it fundamentally alters the nature of the employment or the good or service being offered.
Okay.
The definition of undue hardship has also been clarified in court decisions. The Supreme Court of Canada stated that the employer doesn't have to change working conditions in a fundamental way, but does have a duty to arrange the employee's workplace or duties employee to do his or her work. So that's the obligation. Disability-based human rights violations are among the most common. Disability-related complaints made up between 30 and 60% of complaints in the provinces and territories, and 50% of complaints to the Canadian Human Rights Commission between 2009 and 2013.
It is very high.
Right, especially considering that people with disabilities are a fairly small percentage of the population.
Yeah, we are something like 17%, and we show for 50% of the
complaints.
It's very, very high.
Yeah. According to a report published by the Canadian Human Rights Commission in 2015, the Northwest Territories Human Rights Commission received 51 complaints of disability discrimination out of a total of 101 complaints from 2009 to 2013. So that's half. Half of them were disability complaints. Yep. Disability-related complaints increased between 2011 and 2013 from 55% to 73%.
Wow.
So that's a substantial increase. And, the more people understand that they have rights, the more they're going to use them, and that's great. But it also means that there are a lot of complaints.
Yeah.
It just reveals how much discrimination already exists. Here are some notable disability complaints from the Northwest Territories Human Rights Commission dealt with. In 2008, the commission found that the Frolic Bistro Bar discriminated against a woman who was forced to leave with her assistant's dog after being told the dogs were not allowed in the bar. The panel found that the Folic's conduct violated the Human Rights Act, but did not award monetary damages. And that is something that happens a lot to people with assistance animals, that they're, restaurant owner, you can't have that dog in here, you get it. And, you take out the little card that they give you when you get a guide dog or an assistance dog, and you show it to the owner, and sometimes they'll just say, I don't care, just get out of here. So,
yeah. remember when you have a god door, the restaurant in Toronto we enter in first, we have difficulty to enter the door.
Right, right, exactly.
But with some menace, we enter the door.
Yeah, with persuasion and
heavy persuasion.
we got in.
Call the police.
Yeah, you have to start out by being really nice, educate, but then if the person still isn't responding, you have
Please call the police, you will be sued.
You have to, well, not call the police, but this is a violation of my rights and you're going to come before the Human Rights Tribunal. Okay, in 2016, the commission found the city of Yellowknife had discriminated against a woman with physical disabilities and ordered the city to complete accessibility renovations to a public pool. The commission also ordered the city to stop using a discriminatory fee structure for the transit system and to compensate the woman for the cost of bus fare and for injury to her dignity.
Great.
So Yellowknife got smacked down on that one.
Yeah, you have to remember that cities are the governmental organization who are the most in violation of the law.
Yeah.
Higher you go, let's say provincial or federal, things are a lot better. But cities are very, very poor as they making laws and rules.
Right. They tend not to understand why a law is the way it is, and so they basically, why should we abide by this construction regulation that the doors be 32 inches wide? Because it doesn't really need to be that wide. It takes away from the wall. We need load-bearing members next to the door. We don't need it that wide. They don't understand what it takes to get a wheelchair in a door. The Nunavut Human Rights Act has two important exceptions. It does not apply to buildings which complied with the applicable building requirements of any other law when the Human Rights Act came into effect, and it doesn't apply to any other law that the Human Rights Act says is exempt.
So basically it says that you don't have to rebuild if you were built before.
Right. And that's fairly standard. That's very standard. You don't have to you don't have to start construction or new construction or renovations to become accessible if the building already exists. It's just that when you do renovations,
major one,
or new construction, it has to be accessible. The part that's renovated has to be accessible, and generally you have to make the areas around the renovated area accessible as well. Okay, Nunavut's Human Rights Commission website includes annual reports only through 2012. Later annual reports can be found on the Legislative Assembly's website. It took us a while to track those down. The one case file available concerns a decision made in 2011 where a man was injured while working in a mine 3 months before he planned to leave his job. So he was injured. He was going to leave. He had a date to quit the job, and then he was injured 3 months before that. A doctor cleared him to return to work. So he got well enough to go back to work. But the employer told the man that he could not return to his job since he had already planned to leave. The tribunal ruled that the injury counted as a disability under the Human Rights Act, and that the man should receive compensation equal to the amount of pay he lost. So they basically said, you were discriminated against based on a disability that, they said you weren't up to doing your job. And so your human rights were violated. The most recent annual report from Nunavut, 2014 to 15, provides statistics on the number of disability-related complaints. Of a total of 90 complaints filed between 2004 and 2013, 15, I'm sorry, 22 complaints, or 13%, were based on disability. So remember, we're talking about very small populations. So 90 complaints overall in that period of time of 10 years, and only 22 were about disability. That's 13%. Like Nunavut's legislation, the Yukon Human Rights Act does not apply to buildings which existed when the law came into effect. According to a report from the Canadian Human Rights Commission, the Yukon Human Rights Commission received 46 disability-related complaints out of 106 total complaints from 2009 to 2013. 31 concerned employment and 15 had to do with public providing services. One notable disability decision from the Yukon concerned a woman with fetal alcohol spectrum disorder who was evicted from her apartment. The Human Rights Tribunal found that though the language of the statute limits the duty to provide for special needs, quote unquote, to physical disability, quote, case law would hold that accommodation is required for all disabilities, unquote. The board also ruled that the accommodation she asked for, that the landlord interact with a social worker from the agency specializing in her disorder, was reasonable. And since the landlord knew of the claimant's disability and did not accommodate her, a human rights violation was found. So, it seems like there's a pretty large number of complaints based on disability, and obviously not all of them succeed, but in the Northern Territories, it's something that people are making complaints about, and some of them are succeeding.
So it means that quite a large number of complaints are filed,
right,
compared to the population.
Right, exactly. Okay, so we have an announcement, which is that we need YouTube subscribers.
We need YouTube.
Right. In order to use the YouTube mobile application to run our webcasts when we're on the road, we need 100 subscribers to our YouTube channel. Note that the channel is under my name.
If you don't wish to see us every week, just ripped off the.
You can set it to not receive notifications.
Delete it, yeah. Okay, but
delete it, but just set to not receive notifications.
Yes, okay, great. Or delete the message that you receive. But please file.
Right. If you subscribe and we get 100 subscribers, then we will be able to use the mobile app that enables us to.
Everybody who follow us must subscribe, please.
Right. That would be great. That would be good. And we have the address on our text version, which is available on our Facebook page and our website. And if you want to find it, you can just search for YouTube Euthanasia Disability, and that'll lead you to our YouTube channel. Okay, so if you have questions or comments on what we talk about here, you can go to our Facebook page at facebook.com/toujourvivant, not dead yet, and leave us a message there. Or you can go to our website at tvndy.ca, and we just put up the comments on the proposed regulations for the assisted suicide and euthanasia law, so you can look at that. You can send us an email at info@tv-ndy.ca, or you can follow us on Twitter @TVNDY. Thanks to Christian for helping out.
Thank you,
Thank you for being there, and we will see you next time.
See you next time, and next time we will ask again.
Yeah, okay.
Bye.
Bye.